Good evening, everyone.
Ready to start?
Our talk this evening will be about several subtopics that come out of the recent Health Care Act and raise a number of interesting constitutional issues. I'm John Roland. I am noted as the founder of the Constitution Society and the webmaster of Constitution.org. I also have a blog, many blogs actually, but the most noted one is at constitutionalism.blogspot.com. And in the next slide you'll have the links to those. Now they appear to be gray because we don't have internet access to this facility we discovered, so we're not actually going to be able to go to them to show things, but I'll just wave my hands and try to fill in verbally. There are actually more than one healthcare bill. The one that was passed, the big one, and then they passed a small one with corrections. We haven't seen that yet. We don't know what's in it. It hasn't been published. It'll be interesting to find out. What has aroused a lot of hostility toward it are penalties for refusing to purchase health care insurance of the kind that would be acceptable to the federal government, which raises all kinds of constitutional issues. However, next slide, there are holes in the original health care bill. It seems to avoid many of the points on which it could be legally challenged by waiving criminal penalties for failure to pay the penalty for failure to purchase insurance, and refuses and forbids the IRS to collect using liens and levies.
So it's not a penalty?
Well, you would think so, but it would seem to make the penalties uncollectible. And as you know from law, if there's no penalty, it's not a law, right? Well, next slide. The IRS can still get the judge to throw you in jail for civil contempt for failing to pay. It's not a criminal penalty, it's a civil penalty. Of course, they can keep you in jail until you pay, which could be 20 years. It can withhold the penalty from any payments from the U.S. government, such as refunds, Social Security, veterans benefits, and so forth. And it can take the penalty out of any tax payments first, leaving you owing a remainder on which they can then charge interest and penalties. So, this is an artful example of government by indirection. And it's a method which is continually being used, has been for a long time, but it's mounting in ferocity. It's the use of government actions which, without actually mandating or prohibiting anything, indirectly induce people in and out of government to behave in ways that, if done by direct mandates or prohibitions, would be open to legal challenges to their constitutionality. In other words, you don't actually say do this or don't do that, because you could go to court and challenge that. No, it says it sets up a situation in which emergent behavior develops that accomplishes the same purpose. Next. An example of indirection is the income tax on compensation for labor. There is actually no statute, constitutional or otherwise, that requires anyone to file or pay. When my friend Peyton Motta-Headed offers a $100,000 bounty to anyone who can show a law that requires anyone to file or pay, he can be
constitutional amendment, the 14th Amendment or something?
16th doesn't do that.
that's not that.
No, it's not that. It wasn't ratified anyway. But Peyton can be quite confident that no one is ever going to be able to collect because no such statute exists. No such regulation exists. The first time you see any indication of a requirement to file or pay is in the instruction booklet.
Which instruction booklet?
The instruction booklet for the IRS forms. So it was written not by Congress, not even by the IRS as a regulatory agency writing regulations, that simply has an instruction booklet. And I have sat in a courtroom where a defendant was being criminally prosecuted for failure to file and pay, and heard the judge read out his instructions to the jury from the instruction booklet and telling the jury fraudulently that that was the law. Of course, the jury didn't know any different. So, what it does, it creates an army of administrators and encourages to use their own discretion to make rules and apply them to people. It encourages judges to defer to the agents and lie to jurors in their instructions. And the effect of it is to reverse the burden of proof. You go from the government having the burden of proof that you owe the tax to the burden of proof being on the citizen to prove that he doesn't owe the tax. I remember an audit of my mother where the IRS agent just came in and said, okay, we have a total of all of your income. Now tell me why this doesn't all belong to the government. Prove to me why we can't take it all. So, next.
Are you telling me I don't have to pay income taxes?
Legally, no. But of course, they'll throw you in jail if you don't. But not lawfully. They just do it.
Who's the
And the
enforcers here?
jury will probably let them get away with it.
Who's the enforcers here? Who enforces it?
It's enforced by the courts. The courts are corrupt.
I agree.
Yeah. And of course, the juries are dumb.
The enforcement is, they have their own enforcement, their own federal agents are federal agents to enforce.
Yeah. So that's how we've gotten to this situation. Another example of indirection: the use of Social Security numbers for identification. It is not legally required that anyone have a Social Security number. No requirement. Can't be. It would be unconstitutional. For that matter, it's not even constitutional to require anyone to have a name. There's nothing in the Constitution, state or federal, that requires anybody to have a name. There used to be lots of people who didn't have names. Yeah, they could have a different name every day. Nobody can stop them. Okay. The Social Security Administration itself says in its documentation that it is not to be used for identification. Comes right out and says so. Can't challenge it legally for, saying otherwise, because it doesn't say that. And yet everyone is encouraged to use it for identification, and too many do. That's not because it's the law. Now, if you go to a bank and try to open a bank account without giving them your Social Security number, they say, oh, it's the Patriot Act requires us to collect your Social Security number. No, it doesn't. Nothing in the Patriot Act requires anyone to provide a Social Security number in opening a bank account. It asks the bank to verify the identity of the customer. How they do it is up to them. But they glom onto Social Security numbers because that is the basis for the credit reporting system. They hope to eventually loan you money at interest, and they want your Social Security number handy when they do that.
John, is there anything other than the Patriot Act and banking laws and rules that require social?
No, there's there's nothing anywhere that requires it. Doesn't exist, yeah.
But the old adage is, if you don't file, you don't have to pay, but you have to file, or they'll throw you in jail.
Actually, that's not what happens. The old adage is wrong.
Okay, good.
You don't have to file, you don't have to pay, but if you don't file or you don't pay, they'll throw you in jail. Yeah.
Is it now a felony to fail to file an income statement?
No? Well, they've made it a felony indirectly. They don't make that itself a felony. They make it a felony to impede the action of a federal agent. And then they leave it to whatever to interpret what that means. So in effect, they're saying that by failing to file and pay, you are impeding the duties of a federal agent.
So this agent is like a king. He can say whatever he likes.
That's right. And assessments are typically pulled out of blue sky. Okay, you know, so the evidence shows you only made $4,000 one year. He can say, oh, you made $4 million. You owe taxes on $4 million. Prove that you didn't make $4 million or owe taxes on it. Says, well, I can't prove that I didn't make any money. And how do I prove that? Well, too bad. You didn't file, you didn't pay, off to jail. He has the IRS agent has total power. But if you try to sue them on that basis, first of all, there is a statute forbidding or removing the jurisdiction from federal courts to sue for injunction against collecting. And the statutes, the judicial rules, provide judicial remedies for all challenges, except they just won't go anywhere. So you can't really complain that there are no remedies. It's just that they're made inaccessible as a practical matter. So, as I pointed out in previous talks, you know, for every right there's a remedy, that usually more than one remedy. But if remedies are made too difficult to obtain, then the remedy is essentially put out of reach, and you don't have the remedy as a practical matter. And that's the main way in which government has been progressively tyrannizing us. They make remedies more and more expensive and difficult. First of all, they require you to have a lawyer, pay more money than the case is probably worth to fight it. They've set up all kinds of impediments. If the lawyer makes certain kinds of arguments, he can be thrown in jail or fined or disbarred. And they regularly do that. You know, all these so-called rules, you know, unauthorized practice of law that were sold as a consumer protection measure to protect the public from bad lawyers, that's not what they're for. They're to protect lawyers from the public when they screw up. Except they're also used to protect the judicial system from dissident lawyers. You can't get a lawyer to represent your interests honestly in the federal court system, or for that matter, most state courts, without risking being disbarred, thrown in jail, or sanctioned with fines. Because, you know, you can do it on marginal issues, but if you do it on anything important, you're going to lose your lawyer. He's probably not going to take your case at all. Because he's going to argue reasonably, hey, if I do this, I will no longer be able to practice law. You know, is it really important enough to give up my career just to argue your case when it's probably going to lose anyway? So that's the situation we are in. Lawyers are no longer allowed to represent their clients honestly or competently. They're only allowed to operate within certain rules. And those rules do not allow for representing the rights of citizens. So, Next point is a federal felony to misstate a social security number for any purpose. Fill out a rental application, open a bank account. Anytime you're asked to provide a social security number, if it is later found to be incorrect for any reason, a data entry error by a clerk in Jamaica or something, it is presumed that you misstated it. 5 to 10 years in prison. If you got competent legal advice on the subject, you would never give your social security number to anyone for any purpose unless the whole transaction were videotaped with witnesses present. If you don't have a lawyer with you when you give a social security number for even the most innocent of purposes, you're opening yourself up to prosecution. And if challenged, let's say that you're asked to give your social security number to get a driver's license. You can say, well, I refuse. And that's okay, you don't get a driver's license. If you litigate on the subject, it says, well, you don't have a right to a driver's license. You don't have a right to a job. You don't have a right to health care. You don't have a right to any of this stuff. They're all privileges. I mean, just because you're going to die without them, you know, that doesn't mean you have a right to them. So, if you challenge it in court, it will be found that no right has been denied. Now, next. You might call this process Sunsteinism. Now that Cass Sunstein has been appointed as regulatory czar for the Obama administration. Sunstein is noted as an eminent legal theorist. He's one of the tops in the field. But one of the things he likes to advocate is not to directly violate the Constitution. He knows the things that are violations of it. He likes to find clever ways of using government operations to induce this kind of indirect behavior. And although he's not the originator of most of this kind of indirection, which of course goes back to the early 20th century, and well, or further than that, there's been government by indirection throughout history. But he is now bringing it to the forefront. And we can expect a lot more legislation in which he's probably played the hand in writing to accomplish this in this way. And we, of course, are faced with the problem, well, you can't really go to court to challenge it. There's no point of attack. You can't say this statute is unconstitutional, or that statute is unconstitutional, or that regulation, or even that action by a federal official. Because after all that an administrative agent, like an IRS agent does, is issue a finding. It's still up to a court to confirm the finding. Remember, administrators are an ancient institution. Courts have appointed administrators to investigate and report back to them, and then the judge can accept their reports or not. And originally, they were supposed to be able to provide proof of their findings. But what has increasingly happened is that judges defer to administrators, just accept their findings as a given, and leave it then up to the opposing party to prove that they're wrong. That again has the effect of reversing the presumption and putting the burden of proof on the citizen. Next. Now, some of you may have heard of the lawsuit that's been filed by a number of state attorney generals. There is a potential role for litigation in this field, but the bill lawsuit that they filed does not do it. It's shot through with all kinds of weaknesses. I know the guy who authored it, David Rifkin. He's a sharp guy, but he's operating under very difficult constraints. And one of the constraints he's operating under is he doesn't want to challenge too much as unconstitutional. If he feels that if he took on everything that's unconstitutional, he'd be blown out. The court is just not willing to go that far. On the other hand, the only legal arguments that have merit to blow out the health care bill also blow out Social Security, Medicare, Medicaid, the income tax, and all these other things.
Hallelujah.
Hallelujah, yeah.
And of course, we know the courts are not going to hear that. I mean, it won't survive the first day when the government will make a motion to dismiss for failure to state a claim and for lack of standing. And be blown out. Won't even make one day. Now, I have Trigg v. Pennsylvania up here. This is an old case in which a state tried to nullify a federal statute by just declaring it unconstitutional and directing its officials to refuse to comply with it. And the Supreme Court ruled that the state had no authority to do that, but it didn't really matter because it didn't require the cooperation of state officials anyway. Federal agents could enforce it directly.
What year was that?
I forget. It was before the Civil War. Now, two cases were consolidated, which is why their volume and page numbers are the same. Massachusetts v. Mellon ruled that a state may not represent its citizens in court, federal court. In other words, if the federal government violates the rights of a citizen of a state, the state may not go in and representing his rights. What the court said, in effect, the guy has got to go into court on his own. We don't want to hear the state representing him. Second one, Frothingham v. Mellon, ruled that the party must first have been personally injured to have standing to sue. And this is discussed in this law review article by my friend Steve Winter. This was generally considered the first case to introduce the notion of standing as we have it today. There was an earlier primitive version of it in which a person could be denied what would later be called standing if you were suing for damages and hadn't experienced any. But this was not a suit for damages. It was a suit for declaratory and injunctive relief. Right? Injunctive relief is where you're trying to get the court to either demand that the opposing party do something or forbid him from doing something. And declaratory relief is simply a statement of what the law is. And the court says, we're not in the business of writing law review articles. We're not a branch of the legislature. We don't want you bringing every piece of legislation that Congress passes to us to have its function as a third branch of Congress. If and when somebody gets personally injured, then maybe we'll hear the case. But
So what are they there for?
if you're just trying to get them to stop injuring you, well, maybe, probably not. Especially if it involves taxes. Frothingham was a income tax case. Surprise, surprise. So they essentially ruled that you can't go to court and get an injunction against the IRS to get them to stop whatever they're doing. Next. None of the state nullification statutes will work. States have no legal power to rescind or repeal federal legislation or to impede or penalize federal agents for attempting to enforce it. There is no such power. In fact, it would be a violation of federal felony statutes to try to impose penalties on federal agents.
What about Thomas Jefferson and the Virginia resolves and James Madison and the Kentucky resolves? I thought they stated they...
Yeah, they did, and that position has since been lost as an issue in the courts. Maybe not forever, but for the moment, we're having to fight against all these precedents. And if you're arguing against precedents, you have two choices. You can either argue to overturn the precedent, which is hard, or to distinguish your case from it. And the current suit by the state attorney generals does not really distinguish this case from these others. So that's why it's not going to work. Now, in most cases, the agents would not even be doing enforcing. They would just be making findings to which the courts would defer. And you can't sue a judge for the decisions he makes.
Why not?
Because he has official immunity. You can sue him for, you can't impeach him, you can't sue him? You can appeal if you have standing, but you can't actually sue him for damages for the way he makes decisions. Yeah.
Article 1, Section 8 specifically defines what the federal government can do. If the federal government steps outside of those discrete powers, would they not be acting unlawfully and under color of law and would not their actions be by definition criminal? And as such, would it not be within the powers of the sovereigns of the states to protect and defend their citizens?
Well, you would think so, but unfortunately, a remedy is not afforded for that situation. Next slide. What alternatives do we have? If we can't get relief in the courts, or if we are only a minority who haven't been able to win enough elections on our issues, and just because your candidate gets elected doesn't mean that he's going to do anything on these issues. Chances are he's not. So about the only nonviolent alternative we have left is civil disobedience. If enough people do that, the result is nullification, which is the key topic of this talk, as the actions become effectively unenforceable. Nullification is not rescission, it is not repeal, it is civil disobedience.
But the states don't have the power to do that.
The states don't, but they can provide leadership as long as they're not actually directing positive action. We get into that next slide. About the only people who can individually engage in nullification with impunity are jurors. But most jurors don't know how to recognize violations of constitutions to know when to nullify. Jurors need credible guidance for nullification from civic leaders and officials. Just a private association going around waving signs isn't going to do it. Most people, when they get to the jury box, they might see all those signs out there, but they don't know how to assimilate that. They're not going to hear legal arguments in the courtroom. The judge won't let the lawyers make arguments on points of law. Now that's a violation of due process. The original standard of due process was laid out very well in a case called Stettinius v. U.S., which is on our website, in which Judge Grant, who was then one of the leading jurists of the time, laid out in no uncertain terms that the lawyers in case have the right to argue all points of law to the jury up to the point where the judge gives his final instructions. And they have a right not to have the judge make a ruling on any motion until all arguments are completed. And therefore, until they have made them before the jury. Now, somewhere along the way, judges started saying, okay, rather than wasting the jury's time, let's just have everybody file their briefs in writing, their motions and briefs in writing, in advance of the trial. After I've got them all on my desk, then we'll convene the trial and impanel the jury. In the meantime, I will be deciding the motions on the arguments in my chambers. So, and he does that and often makes rulings on the motions before the jury is even impaneled. So the jury never gets to hear the arguments that such and such is unconstitutional, that there is no statute, or if there is, that it's unlawful. They never get to hear that. Now, a lot of people have the mistaken notion that a judge is an expert in the law. Wrong. Unless it's a case very much like many other cases he's handled. If it involves new issues, chances are he's learning it for the first time. He is being educated by the lawyers. But chances are the lawyers themselves are educating each other.
I've heard they want Hillary Clinton to the Supreme Court.
I've been involved in a lot of cases where I was educating the opposition, throwing things at them that, you know, they were not at all prepared for, and they didn't hit the books. I got the county attorney for Williamson County, Texas, to once say that I was the best lawyer of the 18th century. And of course, I pointed out that the Constitution is an 18th century document. So, the judge is not, in general, going to be an expert in the law. In many cases, he's not only hearing the arguments for the first time, but he's probably not even reading all the briefs that he gets. He may have decided he's going to give 30 minutes to this case. It would take 2 weeks to read all the briefings. He's not going to read them. He's going to say, I know this lawyer, I don't know that lawyer. I like him, I don't like him, I'll decide in his favor. That's the way things actually work. So don't ever imagine that you can go into court with meritorious arguments and that those will have some magic ability to make the judge do what you want.
I agree.
It doesn't work that way. What usually works is wearing down the opposition or wearing down the judge. You make them spend too much time and money. They may eventually just give up and let you have your way just to get rid of you.
Paperwork.
But it's not the legal merits. And don't ever believe anybody who tries to sell you a package that is guaranteed to work in court. You can be sure that it's fraudulent. Okay, next slide. Because of all these factors, I've tried to devise a way in which at the state level we could get leadership by state officials to get the public to cooperate in this kind of civil disobedience. And the proposal is to create what I call a nullification commission. It would be a grand jury. A grand jury, much like others, except that it would have special powers to require state officials and agents not to cooperate with what it finds unconstitutional. So if it found, for example, that requiring people to buy health insurance was unconstitutional. Then he issued an edict to all state officials. You will not cooperate with federal agents to help them enforce this. We can't have you obstruct what they're doing, but you don't have to cooperate. If you're called to provide information or documentation, don't do it. If you're subpoenaed, don't give it to them. All right? If you're called to testify, remain silent. And you won't lose your job if you do all these things. You will lose your job if you do. And he would also authorize financial and legal support for disobedient citizens in trying to carry out his findings. Now, you can't actually have the AG or anybody representing the state go to court to defend the rights of its citizens. But it can pay for lawyers, private lawyers. Okay. It can cover your expenses for, food, clothing, shelter, keeping your self in a viable situation. And if you go to prison, it can pay you while you're in prison, and when you get out, you'll have a nice little nest egg. So that takes a lot of the sting out of civil disobedience. Most people are not willing to civilly disobey if they're standing alone. Anyone who's been in the military, especially in combat, you know that men can be very brave when they're with their buddies. They'll die for their buddies. They'll risk their life for their buddies. It's very hard to get them to stand alone when everybody else is opposing them, especially if it's their buddies. Okay, so to find somebody who is willing to stand alone against the world on principle is tough. So what we have to do is, in fact, we have to create a herd around us all that will back us in doing the right thing. So nullification doesn't work if only one person does it. It only works if a lot of people do it over a period of time. Yeah.
There was one of the eastern states I heard was working or passing legislation that made it illegal for them to go along with the Obamacare, making payments to it, and following the federal legislation.
Yeah, I think you may be thinking of the Virginia legislation, and that's trying to make it a penalty not for the state officials, but for the federal agents, and that was one of the ones that won't work. Yeah.
I guess the question I've got is, could this grand jury make it, say, punishable for a citizen to cooperate with federal law?
No.
Let's take a banker.
No.
A banker can be presented with a search warrant, and they have to come by an FBI agent, okay, without it being signed by a magistrate. And they are required by federal law to comply with that. To me, that's, it's got to be signed by a magistrate, I think. Now, could you require that jury to say if that banker complies with that, he's violated state law?
No. I've examined that issue, and the simple answer is that any such statute would be thrown out by the court. The state doesn't have the authority to require citizens to be civilly disobedient. Okay? But it can support them if they are. So we're walking a fine line here between what will work and what won't work. And this is it's a continuing problem. I mean, I've sent this proposal to members of the state legislature. I've only heard from one of them. He seemed to like it, Leo Berman. I'm not sure if he's really studied it. The problem is, though, that these subtle points are difficult to explain to a lot of people, even state legislators. They tend to take very simplistic approaches to things. Even the lawyers take simplistic approaches to things. And this is a job for people who can exercise very subtle judgment. Have to very carefully craft this kind of thing, or it'll be blown out. So, at this point, I'm just trying to get enough people to read it and study it and understand it, to thoroughly understand it, to understand exactly why every word is written the way it is, just the way it is, and not in another way. Because if you don't do that, you won't really be able to support the effort. Next. Now, examples of nullification that have been occurring recently. The Real ID Act. The government, under the Homeland Security Act, required, this is a separate act, but it's bundled with it, to require state governments to issue driver's licenses or other state identification that met certain standards, federal standards, one of which is to provide a Social Security number. Now, the requirement is not on individuals to provide a Social Security number. The requirement is on the states to provide if they provide an identifying document, to do so in a way that will enable a person to be able to exercise certain federal privileges, such as entering a courthouse or getting on an airplane. They made getting on an airplane a federal privilege. That's unconstitutional, of course, but they do it anyway. Which means that the state of Texas may have to organize its own airline. I know some people who might just do that. Anyway, a lot of the states are refusing to go along with that. Texas is one of them. It hasn't actually said we refuse to do it. It just says we won't fund it. Too much money. But every one of you, when you go in to get your driver's license renewed, you need to file a statement with the poor DPS trooper that's, okay, I will not give you my Social Security number unless we videotape the session and have my lawyer present. And I object to you keeping a record of my Social Security number anywhere in your records. And yes, I do demand a driver's license because, as a practical matter, it's a necessity for life in today's world. And no, I don't need to have identification that can get me into a federal courthouse. If they want me in a federal courthouse, they can come get me. And imagine being subpoenaed to testify as a witness in a federal courthouse. And so, you know, I'm been subpoenaed to appear as a witness. Okay, show us your identification. Okay, well, I'm sorry, sir, but that state identification doesn't meet our Real ID standards. You can't come in. So, well, I've been subpoenaed to appear. Well, if you don't appear, we'll issue a bench warrant to, you know, on a contempt of court, and we'll come out and arrest you. It's okay, but I'm here to testify, but, you know, if I can't get in, I can't testify. Maybe we could testify out here in the parking lot. So no, we can't testify in the parking lot. Tell you what we'll do. We'll issue a bench warrant and we'll arrest you and haul you in. But won't I need identification in order to get into jail? No, you don't need identification to go to jail. Then, of course, we have medical marijuana statutes. Movements in a number of states.
John, how will they know they've got the right guy to throw in jail if he doesn't have a real ID?
Yeah.
I don't care.
He just says he is. And how are you going to prove he's not? I mean, you say, well, you know, I get the subpoena for John Doe, and yeah, John Doe is my name some days. Some days it's not. Well, what is your real name, sir? Well, You know, remember the name John Doe was invented by the courts to use for people who didn't have names, not just who weren't identified, whose names were unknown, but actually for people who really did not have names. There were a lot of people in the early part of this country, you know, who were born and grew up and never got a name. They were just referred to as that boy. You know, hey, you. And a person, of course, in those days, anybody could adopt any name you wanted. You know, Billy Sunday, Wyatt Earp, whatever you wanted. So, you don't own your name. You can use any name you want, as long as it's not for fraudulent purposes. So who is anybody anyway? There is no requirement to prove you're a citizen. The burden of proof is on someone else to prove you're not a citizen. So how do we keep illegals out of the country? There's no way. You know, you can,
Rifles work.
if you know that they're not a citizen. But suppose he's a natural-born citizen. I know a lot of natural-born citizens, second generation, who do not speak English. They've never got, it's not in their family tradition. For all they look just like a guy just snuck across the border. He's born here, so is his parent. You know, so what are you going to do with it? That's that kind of situation. Anyway, a lot of folks in several states lobbied for medical marijuana laws, which of course is in defiance of federal statutes. One of my friends, Randy Barnett, who's a good guy who agrees with us on a lot of things, argued the case, Reich v. Gonzalez, and lost, in which he argued that marijuana for one's own medical use was not interstate commerce.
If you can't grow wheat in your backyard, what isn't interstate commerce?
Well, see, that's the problem. We had most of you are familiar with the Tea Parties. And one thing you may have noticed about the Tea Parties is that they don't have any solutions. They have a lot of protests. They are generally aware of their problems, but when you try to get specific action plans, they tend to fall a little short. The Continental Congress 2009 was intended to come up with action plans, and it did. Not everyone is satisfied with them. They were kind of a least common denominator, what we could agree on. They did not include things like my Nullification Commission, which I didn't present to them anyway. Recently, a lot of the Tea Party activists created a website called Contract from America, inspired by the Contract for America from 1994. And they asked people to submit all the issues that they could think of and the remedies, the action plans to go with each of these problems. And they've come up with a bunch. The good news is that the leading issue was compliance with the Constitution. The bad news is the only action plan that they could come up with or get behind was a bill to require every federal statute to show its constitutional authority for every provision. Now, a moment's reflection should indicate that while this has some merit as an aspirational sense, in fact, what would happen is what the Congress is already doing. What they regularly do for every federal criminal statute, and most of the others as well, is they have this boilerplate language. This will have a substantial effect, if not passed, will have substantial effect on interstate commerce and is therefore constitutional. So Congress is already formally meeting the requirements of the Enumerated Powers Act. But it's doing so in a way that's meaningless, because then you have to address the question of what is commerce, and also what is necessary and proper. A lot of people point out, well, the courts along the way started including things in commerce that weren't originally considered to be included, like services, manufacturing, primary extraction, energy, information, all kinds of things. Well, by the 1942 case of Wickard v. Filburn, which is the basis of almost all federal criminal statutes today, the court essentially abandoned that approach and says, okay, we can't keep expanding the definition of commerce. It's getting ridiculous. But what we'll do is we'll say under the necessary and proper clause that this, that, or the other has a substantial effect on interstate commerce, and therefore we can include a regulation of that. Not because it is commerce, but because it affects commerce. Well, once you would allow Congress to regulate anything that affects commerce, you've opened the doors to doing anything.
So we have
Yeah.
parliamentary.
So what was the original definition of commerce?
The original meaning of commerce is not easily defined, actually. I had to go to various repositories of documents from the early Republic before the colonial period. The American Antiquarian Society is a good source there in Massachusetts. And where I could find, the word commerce was almost never used in the 1787 time frame. You won't find it anywhere among the writings of the founders except when they're referring to the clause in the Constitution. You don't find any background use of the word commerce. All right? The earliest time you can find references to it in law is in English law, where it's referring only to shipments to foreign countries by water. Now, obviously, the founders weren't confining it to shipments to and from foreign countries by water, but the few references you can find to the use of the word commerce refer to the items that were listed on the price sheets published on a daily or weekly basis in the colonies and in the early republic. Most newspapers in that time were just price reports. They didn't have editorials, they didn't have news about, local events. All they just had were lists of prices. Bushels of wheat, or ingots of iron, or, hides, or whatever was being shipped that day. No services. You didn't see any quotes for, barbers, haircuts, or dental work, or anything like that. It's only tangible commodities. So from that, we can reasonably conclude the word commerce originally meant only the transfer of title and possession from outside a state to inside a state of a tangible commodity.
Or vice versa?
Well, actually, there's no power to regulate exports, only imports.
Okay.
And we cover transfers between states from outside the state to inside the state.
I was under the understanding that interstate commerce was essentially the same as foreign commerce. It's really no different.
Well, in a sense that's true, but if you're trying to state it succinctly,
But it'd be hard to construe it the way the Congress today construes interstate commerce, to put that against a foreign country and try to regulate foreign commerce the same way they today regulate interstate commerce. It would be ridiculous.
yeah. Well, the other thing too is that the word regulate has changed its meaning. The original meaning of the word regulate was to make regular. It did not include the power to prohibit. Now you can say, well, it's a kind of prohibition. You're prohibiting certain modalities. concept behind regulate, as the term was used in that era, was you could restrict certain modalities of things, but not all modalities. So you could restrict the packaging and labeling of some product, so it had to be in a sturdy box, and it had to be labeled with its contents and the weight of the contents. But you couldn't prohibit that item from being shipped and sold in some form. Only the form of it could be regulated. And you could require that it goes through a certain port, an inspection point. And once the inspector said, okay, this is commerce subject to regulation, or no, this is not commerce subject to regulation, he just sends it on its way. And he can't charge a fee if it's not subject to regulation, only if it's a regulated object. So, the break came in 1884 with the first act creating a criminal penalty, which is a prohibition, on shipping tainted meat. And the Supreme Court sustained that provision. It just considered it incidental, not important. But that opened the floodgates. The least little incidental precedent can be used to open up the way to all kinds of legislation and all kinds of litigation.
The Supreme Court is a sham.
Well, except that most of what it does is it sustains the Congress.
It's a sham.
So it's, yeah.
I guess when you gave the definition of how they changed the definition of what's commerce, you know, interstate commerce, to say anything that affects commerce, is that how they now say that they can regulate if you don't do something in commerce?
Yeah.
When they're under Agricultural Adjustment Act, some guy grew more than he was supposed to, so he fed the excess to his animals, and he got found in violation because he was supposed to buy to feed his animals.
That's right.
Rather.
That was Wickard v. Filbert.
Yeah.
So Filbert was a farmer,
Yeah.
and Roscoe Filbert. And he didn't win that one, but because he lost, and of course, let's face it, he was a weak litigant. He provides a good example of the problem that you don't want to go to court unless you are very, very well prepared, because if you lose, you're liable to make things worse for everybody. And what the federal government tries to do, they try to cherry pick cases to make them against weak parties, those that are easy to beat, who don't have a lot of money, a lot of clout, who can't get the best lawyers or make the best arguments, because they want to get that precedent. But even further, the cherry picking is very subtle, because they want to pick people, victims, that are not so weak that they can't make an appeal. They want somebody who was just weak enough to lose and then make an appeal and then lose again. Because it's the appeal that's the precedent. And once they have that precedent, Katie, bar the door. Yeah.
I have a question real quick. How, in regards to the Commerce Clause, it's my understanding is Congress is trying to keep something in the regulation. What about the power of contract? If the federal healthcare bill is now trying to create almost like nullifications of contracts, I guess, because they're forcing you to only get like student loans through one bank now, or that you can only do this through this one entity now. Well, what about the power of the freedom of contract?
Well, we long since lost that in the courts. The original provision is that Congress shall not make statutes that impair the obligations of contracts. But they quickly concluded that was only contracts that existed when the Constitution was adopted. It didn't say anything about new contracts. Yeah.
Legal firm in Texas and several asserts that it has due to the Commerce Clause, so that they can challenge that in Supreme Court. What is their likelihood of succeeding?
Almost nil. Because they're having to go up against not just Wickard v. Filburn, but 70 years of precedents built on Wickard v. Filburn. See, that was a problem that a lot of the people faced after the Civil War in trying to overturn Barron v. Baltimore and the Dred Scott v. Sanford decisions. It wasn't just that you had to challenge those decisions, you had to challenge all the ones built on those decisions. At that point, there were hundreds of them. So the only way they could think of to do that was to adopt amendments to the Constitution. And that's how we got the 14th Amendment. The 14th Amendment was mainly intended to overturn those two precedents and everything built on them. Barron v. Baltimore and Dred Scott v. Sanford. And you can find discussions of that on my website. Now, let's just try to finish up this, then we'll kind of go into miscellany. Governors are refusing federal aid of various kinds. We found Governor Perry, to his credit, refused federal aid to education. Now, he gave his excuse that it would create more headaches than was worth it. But in fact, there's another important thing going on there. What I and some others have been trying to do is to overcome the influence of other states that has brought about the decision to only teach American history from the beginning through 1877 in the 8th grade. The subject is not revisited until the 12th grade, when they teach from 1877 onward. Now, how likely is it that an 8th grader is going to retain enough of American history to understand the American government course in the 11th grade? Well, I have done substitute teaching in public schools, several of them in the Austin area, and I can testify that 8th graders are not ready to learn. They're mostly bouncing off the walls, fueled by sugar snacks and drinks, not enough exercise, and not enough discipline. They do tend to settle down just a little bit by the 11th or 12th grade, not much. In order to get them to settle down for me, I had to tell them stories, entertain them, like about my near-death experience after that. I think some of them began to concern, gee, I wonder if we're going to have a near-death experience from this guy. So I was fairly successful in winning their attention. Because I love kids, and they can tell I love them, and so I can generally find a way to make the subject matter interesting. And some of them even came up and said afterwards that I was a better teacher than their regular teachers were. But I did learn the limitations of what they were being taught. In the sciences, they were actually a little ahead of where we were when I went to school, 44 years previously. But in civics, they were way behind. All the emphasis has been on math, the sciences, some on, literature, but not enough. But the total neglect of civics, government, history, and those fields. Those are the main things we need to be teaching. And they're not. When Governor Perry refused federal aid, what he was doing was refusing the efforts of this nationwide effort to continue this dumbing down process, to entrench the non-teaching of civics in the public schools. Now, we still don't have the teaching standards written, I actually wrote the TEEGs for the State Board of Education, which they didn't adopt. We'll have another chance later. But at least there's a possibility of getting them adopted in Texas, as long as we refuse this kind of federal funding. If we accept it, forget it. And not only that, but Texas will lose its influence over the other states by being the single purchaser of so many textbooks. Right now, Texas standards dominate the nation in the way, because we dominate the way textbooks are written. And under the new federal standards, there's going to be a counterweight to that. So the federal standards will tend to result in textbooks being written differently. So it's a battle going on that's important to our future. So, next. Okay, well, that was the last one of that. Okay, we can go on into miscellany. Any questions?
Can your nullification strategy be employed for other constitutional things, such as the Social Security number, federal income tax, etc.?
Well, up to a point. Again, remember we're talking about government by indirection. You can't really hold emergent behavior to be unconstitutional. All you can try to do is to nibble away at some of the underlying influences done by government. In order to tackle most of those, we're going to have amendments. And if you go to my website, under the political reform page, and scroll down, you'll find draft amendments to the U.S. Constitution. And there are a whole bunch of them there. Essentially, what most of them do is to clarify the Constitution, those provisions of it that have been misinterpreted since it was adopted. Unfortunately, even if we want the Constitution to be correctly construed, we now have to make amendments to get that to happen. We have to be able to say, we are adopting this amendment, this is what the Constitution meant, and now we really mean it.
Do you have words for that?
What?
Do you have words for what that amendment would say?
Yeah, there are a whole bunch of them. It's not just one amendment.
Oh, good. Because I agree with you 100%. You're right on.
Yeah.
But they don't obey what we already have, so they would just
Well,
ignore anything.
This isn't, nothing is a complete solution, because obviously if people refuse to comply with the Constitution, they're limited to what you can do about it. But what a Constitution mainly does is provides a standard by which people can rally behind. You still have to have people enforcing it. But what you have to have is a Constitution that people today can understand well enough to know how to rally behind it. And if you could just have what we have now, just the use of the word commerce or necessary and proper, most people today don't know what those things mean. So we need to add language, for example, that necessary and proper only means to make an effort and not to get an outcome. Commerce only means tangible commodities. Does not include, come right out and say it, does not include services, does not include manufacturing, does not include primary extraction. Those things are not commerce, they're not subject to regulation. Make no uncertain terms. You have to be much more specific. Yeah.
So you're actually saying that anything that goes on the highways is only really regulated if it's a commodity like you're talking about or something.
Right. And not the vehicle that transports it, not the party, the company, or whatever doing the transporting. It's the commodity itself, its attributes. Yeah.
If I understand what you're saying, there's some words and things in the Constitution that do beg for some understanding or better definition. But there's a lot of things in the Constitution that I think are just absolutely stone clear but people have tried to interpret it, well, what they really meant when they said, the doctrine of separation of church and state. That is not in the Constitution. As my understanding, what the Constitution says, Congress shall make no laws as to the practice of religion or the prevention thereof. And yet, Congress is making laws all day long about religion. And I mean, to me, all those laws are unconstitutional. But how is it? To me, it seems like you ought to have some amendments to define those words that do beg for definition.
Yeah,
but then after that, you ought to have an amendment that says the Constitution is to be applied as stated, not as interpreted. And if you want to change the meaning of something, there is an amendment process.
Well, you have to be careful with that, because to interpret something is to get the meaning of it. You cannot understand something without interpreting it. You're interpreting my words now, or it would just be a bunch of meaningless noises. So you can't not have interpretation. But what you're arguing against is misinterpretation. It's when you hear English and you think you're hearing French. That's misinterpretation. So, you can see the progress in law throughout it. People start out with simple contracts. We're married. Okay? And then they get into disputes and says, what does this really mean? What are the duties and obligations of the parties? Who owns what? Who inherits what? Who takes care of the kids? And before you know it, you get through court decisions and statutes and whatever, you begin to get a whole shelf full of books that define the default marriage contract. So when you say we're married, you're invoking that whole shelf full of books.
Is that progress?
Well, the problem, of course, is that the original simple contract didn't deal with sufficient specifics. And if you're going to have disputes, you're going to get into specifics, and then you're going to have to deal with the specific issues.
The original contract had a specific concept, and all the specifics should be derived from that concept.
Yeah, but deriving them is not obvious.
To lawyers, maybe.
But all these laws are really, especially the ones in the last year or so, are really null and void because Harry Satoro can't really sign them.
99% of the laws are null and void.
Yeah.
So what do we do about that? I mean,
That's why we get into proposals like nullification. And if we can get enough states to adopt nullification commissions, then we're going to be developing tremendous political pressure to go after the rest of the violations and to get amendments that clarify things, that define commerce, that define regulate, that define necessary and proper, that define all these other things that are not defined in the Constitution. Remember, the Constitution only has one definition: treason. And it only has that one because they changed the definition of treason from what it had been previously. All the other terms are referring back to the legacy of English law. So in order to understand the Constitution, what you're having to do is to learn a foreign language, the legal English of 1787. And the only way you can understand the legal English of 1787 is to understand the legal English of 1786 and 85 and 84 and go back 1,000 years.
Magna Carta.
Yeah. So there's a lot of reading to be done. When during the Constitutional Convention, the question came up, somebody wanted to introduce a provision to forbid ex post facto laws. And said, well, wait a minute. Would that include civil statutes? Are we going to forbid retroactive civil statutes? Or does ex post facto only apply to criminal statutes? So they looked it up in Blackstone, who considered their authority. And Blackstone says it only applies to criminal statutes. So they themselves in order to understand the words that they themselves used in the Constitution, had to look things up.
Was that version 4, 5, or 6? I mean, what are they using?
What?
I mean, Blackstone has other, different versions, and it says.
Well, there's one version of Blackstone. There were later editions. And the one that they mainly referred to later, not, of course, during the Constitutional Convention, was by St. George Tucker.
Tucker's the West.
Yeah, which is on our website. And the benefit of that edition is that Tucker cleaned up a lot of the errors in Blackstone. There were miscites, volume page and all that in the original Blackstone. And he also added notes to relate Blackstone to the Constitution. So he should probably be looked at as the most authoritative version of Blackstone. Yeah.
You said you were elected to go to the Continental Congress, in 2009, for Texas. Could you describe that process, how you were chosen?
Yeah, we actually conducted a public election. It wasn't quite perfect. See, what a lot of people don't realize is that anybody can conduct a public election. You don't have to be a public official. You can put out notices, set up polling places, and to conduct a public election for any kind of official you want. You create a new kind of official out of thin air. And what we did is we created a new kind of official, a delegate to the Continental Congress 2009. Now, where we didn't quite achieve the requirements of the law was that we didn't post notice in every county in the state. The statute is quite clear. You have to post notices in at least 3 places in every county, and one of them has to be the courthouse door, and one of them has to be in the newspaper of record for that county, and so on and so forth. It has to be a certain number of days before the election. Back in 1995, we conducted an election of a committee of safety. We had militia units in about 20 counties, and we felt that they needed some kind of governing structure. So we organized a public election. We put out notices meeting the statutory requirements. We set up our polling places. We had printed ballots. We had a procedure by which people could add names to the ballot by a certain number of petition signatures. It wasn't very many. It was easy to meet the quality requirement. And we didn't have a very high turnout. It was about 2% in most counties. But that's actually higher than a lot of elections get for positions like water districts and utility districts and things like that. So because the public had an opportunity to vote, it had the authority of a public election. And I can tell you that after we did that, everybody running for public office, constables, sheriffs, mayors, anybody else, felt they had to speak before the Committee of Safety. All of a sudden, we were a civic force in the region. Now, it was only about 20 counties, but we could, in principle, we could have extended it statewide. The point is that there is a way to organize to develop that kind of political clout. And in fact, some of our members of the Committee of Safety went on to become county commissioners. In fact, one of the main problems that we did not anticipate, we didn't have a provision for appointing replacements when people dropped out. Too many of our members were resigning to run for public office, other public office, until we lost a quorum and we didn't have a way to do business to conduct another election. But if we had just avoided that little flaw, there might today still be elections of the Committee of Safety. And you can just imagine what this process could do if extended across the country. And if we got enough of these kinds of, unofficial but legal elections, electing people to represent the interests of the people whose rights are being violated, it would have an impact. Yeah.
Community safety, that was actually an organization over militias in the 2010s?
Right. That they were to be considered the, let's say, the governing body for the militia units.
What about a constitutional convention to rewrite the Constitution and make it clear?
You do not, absolutely do not want to have a constitutional convention today.
Not this one, it's today.
Okay, imagine,
Yeah.
okay, you have to always ask yourself, who would attend
Barack
a
Obama.
constitutional convention? It would not be people like us. What it would be, it probably turned out to be, imagine the Republican and Democrat national conventions, then merge them together into one big convention. I don't know if any of you have ever been to a national party convention, because I've only been to libertarian conventions. But with even 800 people attending, we don't really get a lot done on the floor. You know, a large number of people cannot do something like draft a constitution. It was hard enough at the Continental Congress to draft the Articles of Freedom. The only way that really happened is that we broke into committees, and each committee worked on part of it. If the closest thing to it, I think you would see, would be for the like imagine, like I said, the merger of the two national party conventions, and then a merger of their platform committees. Just try to imagine that. I have sat in on platform committee meetings of both Republican and the Democratic parties, and it's hard enough for them to agree on anything, much less on something they could all agree on. Yeah.
On the other side of that coin, I mean, Debbie and I have been to state conventions, and 5,600 convention in 08, and the herd mentality, the flag waving, people there get told what they're to vote for or what the right thing to do is, and they just follow the herd. So what I'm afraid of is you get a constitutional convention, and you got a few people that are in control and decided what they want. All they've got to do is put the word out, and you get a herd mentality voting that way, and that's not what we want.
Yeah.
I would almost rather have chaos of a bunch of people who can't make a decision on something, so that nothing gets done, unless there's truly an urgent issue that needs to be addressed, and then it will happen.
Yeah. Well, my approach to constitutional amendments is to develop a well-developed set of them with exact language that we can build consensus for among civic leaders and the public, and then take each of these proposals with no changes to our state legislatures and ask them to adopt them, send them to Congress demanding that Congress adopt this amendment with not one word changed. And if they do that, then it comes back to the states for ratification. Again, not one word change. We tell our state legislatures, if it comes back with one word changes, do not vote for it. Not one punctuation mark, nothing changed. We need to control the process. But that means that we need to develop this outside consensus. We need to have people read proposals like mine. You may not agree with mine, maybe you have better ones. Randy Barnett developed a whole set of his own. In fact, I put mine out because he put his out. I didn't think his were very well written. I love Randy, but we have our minor disagreements. But I try to write better ones. That they represent years of work, years of research, careful consideration of every word. Even I keep amending it. as I realize new things about it. It's a continuing learning process. And what I want now is to get more and more people to contribute ideas and objections and all that better language or whatever, so we can hammer out really strong amendments that don't have any holes in them, that anticipate all the ways they could be misconstrued. Because we can be sure somebody's going to try to misconstrue them.
How many states need to go along with an amendment? Two-thirds.
Two-thirds are needed to call for a convention, but we can interpret that. It doesn't have to be that many to simply call on Congress to adopt it.
How many to ratify?
Three-quarters, which is 38.
So we'd have to have 3/4 of the states ask to have this adopted for us to know that 3/4 of the
No, it could be a smaller number to ask for it.
What's that?
It would be a smaller number to ask for it. But it would be a good idea to have enough state legislators on board to adopt it once it came back to them.
But John, isn't this probably getting to be one of the best times to ever think about doing something like that? With everything that's going on with healthcare and education, and the states are getting pretty put out with what they're seeing.
Well, I certainly hope so. This is why I'm talking about it.
Yeah.
How can we follow the dedication ceremony on April 19th? Will that be on your website?
You mean besides coming to Austin?
Yeah.
I'm going to be videotaping, and so will Barbara. So we'll put our, put the videos online, and we'll let you know.
Probably not live, but it'll
Do you think it'll
Yeah,
have
it won't be
any-
live.
If this is going on in every state capital, do you think we'll get any media whatsoever?
Only if we create it. We have to put out videos that go viral. Yeah.
On the healthcare bill, you said that are you talking about the resolution that has not been exposed yet? Remember you said that?
Which one now?
Well, at the beginning of your speech, you were talking about the healthcare bill being
Yeah.
passed,
Yeah.
and then there's some
There's supposed to,
corrections
yeah, the
made,
corrections.
but we have not seen that yet.
Yeah, we're waiting.
Well, isn't that with the reconciliation bill? That they were
No.
calling?
The first bill is the reconciliation bill.
Oh.
The second one is just corrections, which in principle have to also, which in principle also has to be voted on by the Senate.
And it hasn't been shown yet. But
Right.
wasn't all that unconstitutional, their process? Because they voted on, the House voted on the Senate bill that had been passed, and at the same time, they voted on the changes at the same
Yeah.
time. And
Well,
wasn't that unconstitutional?
It's not, strictly speaking, unconstitutional because each house may make its own rules. And those rules can be pretty bizarre. The only thing we can do if they write on, adopt, and use bad rules is to vote them out of office. And what generally happens, actually most of the rules are not bad if they were followed. But if you watch C-SPAN, you'll hear a regular refrain. Mr. Speaker, I ask unanimous consent to suspend the rules, and they do. And without objection, the rules are suspended. So you can't really write a rule you can guarantee will be enforced as long as there are not enough members who are going to insist on enforcing it.
So say again the part that we haven't seen yet, the corrections
Yeah,
to the bill,
to the bill, yeah.
like what?
We don't know yet.
I don't remember that part.
Yeah.
I don't remember that.
Or like I say, we're waiting to find out. When we find out, we'll put the word out.
I heard something, I just wonder whether you know it's true about the healthcare bill, that there's some exceptions as to who it applies to and doesn't apply to. Like it doesn't apply to Amish, it doesn't apply to Muslims, and you heard something about that?
Yeah.
It doesn't apply to
It doesn't say so by name. It doesn't name the sex. It just has weasel words that allow it to be interpreted to accept them.
I'm a weasel.
But it doesn't allow.
But it could, in fact, include other people. the way the weasel words are written, you might be able to accept yourself. For example, the Constitution Society, my organization, is a church under IRS Section 508. It means I don't have to file a letter, I don't have to file a report. Donations are deductible, but I don't have a letter I can show you to say that it's deductible. So if they challenge your deduction, you're going to be up to you to prove that the money was used for a deductible purpose. But it's still technically a church. And you can simply say, you know, we're all constitutionalists, we're all members of the Constitutionalist Church. Well, that's my organization. You know, several guys, Rousseau, Montesquieu, and Abraham Lincoln wrote about the need for a civic religion, by which they meant a kind of a civic ideology, secular, but effective, in which people all agreed on certain values, and that was for provide the moral foundation for that society. It could be a religion, or it could be a secular doctrine, or ideology, or whatever, but they felt that we had to have one. Well, guess what? Constitutionalism. And it's the one religion that is okay for to be established, because it's the religion of the Constitution itself. And the Constitution itself is an establishment of constitutionalism. I'll have fun if I have to ever argue that in court. Yeah.
I've seen some people asserting, and I haven't done completely the fact checking, but a little bit of fact checking that I did do seem to indicate that there might be a possibility that 30 frequency identification tags might be required under the health, or at least allowed in the health care bill as a way to facilitate health records.
Yeah.
Have you heard anything like that?
Most of what we've heard indicate they want to install them in children,
Yes.
where they would also serve to identify missing or abused or, kidnapped children.
You got my implants?
Implants, yeah. So a person would have it from birth. They wouldn't try to install them in adults who might fight back,
Right, yeah.
but they install them in children because children don't have any rights from their viewpoint.
But they cause cancer, or they've been known to cause cancer in pets whenever they get chipped, whenever pets get chipped. As such, that would be an opportunity for civil disobedience, especially if followed up with asserting one's Second Amendment rights.
Yeah.
Number one. Number two, if anyone was chipped and got cancer from that or some other malady, that might be have standing in the court simply because the person has been damaged by this law.
Yeah, of course, then what happens is that they just say that, you don't qualify for any health care benefits
Because you don't have the chip.
because you don't have the chip.
No, they're just.
It would be, it's the old thing I was saying about Social Security numbers. You're not required to have them, but if you don't have them, you can be denied certain privileges. They're not rights, so you can't sue for them. They're only privileges, and because they're only privileges, you don't have ground standing to sue. Yeah.
They'll put out 10 to 20 government studies, government-funded studies, to show that they don't cause cancer.
Yeah.
Yeah.
Or they'll come out with better ones.
Yeah.
Some of them now are smaller than a grain of rice. They have a limited range, but they're pretty benign. And we can expect that they'll have, benign ones, particularly stuff that can be inserted deep in the body, not near the skin. People can remove them if they're just under the skin. But if it's major surgery to get them out, then chances are people aren't going to be able to do that.
This is in the health field?
No, it's just being talked about. One of the things you have to do when you're dealing with government is to talk to people inside of government to see what the scuttlebutt is on this, that, or another issue. Most of our best information comes from people inside of government. Yeah, they have infiltrated us with their agents. There might very well be an agent in this room. We can look around us to try to figure out who it might be. But we have our agents inside of government too. Anybody, more than one can play that game. Yeah.
I just suggest too that it's not only things that you will find out inside the government, but folks, pay attention to other than mainstream media. If you look around at what's going on, you will see things that are surfaced to see what our reaction will be. And if we don't react, it's going to happen.
Okay, now, we need to kind of wrap up here. I think we have to be out by 9.
We have to be out by 9, everything stacked back.
Which really means by
But
8:45.
if everybody will stay and stack chairs, then we can work until that.
Okay, now, we have a number of things coming up. We, of course, the April 19th event on the state capitol. You're all invited to come down. You know, Austin is a nice city to visit if you haven't been there already. We have a number of other things going on. I'm looking for more speaking engagements like this one. So you can multiply, if you like what I had to say today, you can multiply the range of my voice by organizing more events like this one. And try to find one where we've got an internet connection. And of course I've got videos. I'll be putting this stuff out on videos. You can send email to everybody you know saying, watch John Roland. He's fun to watch. He says quirky things.
He's on Constitution.org?
Well, yes, he'll be there and other places.
Does that mean you're a quirk?
So, and don't forget that I'm running for, not running, I don't say running. I'm a candidate for Texas Attorney General on the Libertarian ticket. So when you see Greg Abbott and Barbara Ann Rodnowski, just remember there's a third guy in that race. The reason I don't say I'm running is because when I ran for Congress in 1974, I felt that, to be honest, I had to literally run on foot from town to town. So I did. 256 miles in 2 weeks. That was a little tiring. Running over the entire state is something that's a little beyond my state of health. As some of you may know, I just had heart surgery this week. David Bell picked me up at the hospital and whisked me off here to the Dallas area to give my speech yesterday. So, you know, these things happen, but I don't think I'm up to literally running on foot from town to town all over the state of Texas. It would be fun, but West Texas, it gets a little boring.
As Attorney General, what would you do different from Greg Abbott?
Well, for one thing, I'd be a crusader for reform and not just an administrator kind of passively waiting for what shows up in his inbox.
You'd be aggressive and assertive.
Yeah. Greg is a nice guy.
Yes, he is.
Yeah. He unfortunately doesn't know the law very well. There are a lot of things he doesn't know about the law. He also doesn't know how his position can be used to work around the restrictions on the office to get things done. Yes, you're only supposed to issue an opinion if the state agency asks you for one. It doesn't work for individuals to ask the Attorney General for an opinion. But you can get almost any friendly state agency to ask you to issue an opinion on any subject you want them to. Okay? The Attorney General is not supposed to prosecute cases in court. DAs have dibs on that, but the AG can go to a grand jury and he can get them to appoint some private person. It's called an attorney pro tempore to represent the state. Texas law allows for private attorney generals. It even provides for paying for them. And by taking advantage of things like that, you can get a lot done. The first case might be to prosecute the DA or the judge. I have a little list of corrupt counties whose public officials would not be missed. The Attorney General has broad authority to prosecute public officials. He can't go after, because of the DA requirement, he can't go after them for the criminal, offense, penalties, but he can go after them to remove them from office and rid of Rampa. We could remove most of the officials from entire counties. There are a lot of counties where you cannot get somebody to run to challenge the incumbents, especially judges, because they're afraid that if they do, their kids will be taken away from them.
Say that again?
There are counties that are so corrupt that, especially for the judicial positions, you cannot get a local attorney to run for judge because he's afraid if he has young children, they'll be taken away from him.
How will they get away from him?
He'll go to court and terminate his parental rights.
Happens all the
And
time.
it happens all the time.
Happening.
Okay? One of the things that I would put a stop to real fast, if you go to Williamson County, which is just north of Travis County, you'll find hundreds and hundreds and hundreds of parental termination cases in the court records. What happens is that the state, to enforce its mandate to collect from deadbeat parents, goes to Williamson County, takes those cases there where they are rubber stamped. Okay? The state and the county and everybody else involved gets up to between $35,000 and $50,000 for each kid who's taken away from his parents.
Isn't that the most corrupt county in Texas?
Well, I don't know if it's the most. I can name a few others that are bad in different ways.
Constitution.
Yeah.
Yeah.
The other ones?
Harris.
Kendall County is a dumping ground for people in the Federal Witness Protection Program. They have a huge number of federal witnesses who continue their criminal activities in Kendall County. They've got the county official totally intimidated, and they're in the process of stealing most of the land in the county from its honest residents. Okay, there are several counties that are along transportation routes from the border that are transshipment points for drugs. We have one of those in West Travis County that extends into Williamson County. All right. The public officials there are corrupt, not just local, not just county, but federal and state as well.
West of Travis County?
Yeah, it's the city of Lago Vista and Jonestown, which are suburbs of Austin, Jonestown is where the actual shipments are transshipped. Lago Vista are where the middle management of the drug trade live.
Okay, so as Attorney General, you just put a stop to all this, you clean it up.
I certainly try. I might get assassinated along the way, but
Now, this is common knowledge, I'm assuming. Now, how come the Greg Abbott doesn't do
in
it?
fact, it was a Republican precinct chairman in Williamson County when I just brought up the subject. And he says, well, I guess that's about the worst kept secret in Texas.
Yeah.
That's what we do. Greg Abbott's office, we get on the phone.
And see, most of the violations of our rights that come from courts start with corruption, mainly due to drug money. Once you pay off judges you not only get judges who protect the real drug traffickers, you also get judges who don't protect rights. Corruption and abuse go together. Yeah.
Please comment on the following. The 13 colonies had a revolution against the tyranny of the British parliamentary sovereignty that ruled them. And so when they won their independence, they set up the Constitution. They set up the concept of the rule of law, with the Constitution being the highest law of the land, and no body being above the law. All through history, the Congress has been stretching the interstate commerce and the general welfare clauses, culminating in the passage of the health care bill, where all constitutional restraints have been eliminated from Congress. So now, today, the Congress of the United States has parliamentary sovereignty, which is what the colonies rebelled against from England.
Yeah, and interestingly enough, in connection with the Constitutional Convention idea, there is actually several groups, although they're loosely associated with one another, who have a well-developed replacement for the Constitution. He would create a system modeled on that of Britain.
Well, Britain has no Constitution.
Yeah, but the form would be written, but it would be a parliament that had all power.
All power.
No Bill of Rights.
Right.